Okay. Good afternoon, everyone. It's such a pleasure to welcome you back to another series, another book talk in our faculty book talk series. Today, we welcome Professors Cathy O'Grady, and online from Boston, we have Tigran Eldred, along with our interlocutor in Phoenix, Professor Keith Swisher. I'm Teresa Miguel Stearns. I'm an Associate Dean and Director of the Daniel F. Cracchiolo Law Library. This afternoon's book talk focuses on Professors O'Grady and Eldred's new book, Beyond the Rules, Behavioral Ethics and Professional Responsibility. This concise book brings behavioral insights to the wide array of topics commonly taught in the required professional responsibility course. Professor Catherine O'Grady is Professor of Law here at the University of Arizona, where she teaches civil procedure, professional responsibility, and a seminar on the United States Supreme Court. Additionally, Professor O'Grady's research focuses on behavioral legal ethics, an area of study that draws on empirical research in cognitive and social psychology to understand lawyer mistake, wrongful obedience in practice, and cognitive optimism in the practice of law. Her work usually includes a specific focus on new attorneys' unique professional perspective in making ethical decisions. Professor Tigran Eldred, joining us from Boston is a professor of law at New England Law, Boston, where he teaches in the fields of legal ethics and criminal law. His research and scholarship focuses on the regulation of lawyers and the psychology of legal decision-making in various contexts, including criminal law and legal ethics. Prior to teaching, he worked as a civil rights lawyer in private practice and as a public defender at Legal Aid in New York City, and as a human rights advocate for the Lawyers Committee for Human Rights. He has co-founded and regularly contributes to two blogs, the Behavioral Legal Ethics and the Continuing Duty blog. And joining us from Phoenix, our interlocutor today, Professor Keith Swisher, who's a professor of legal ethics and director of our Bachelor of Law and Master of Legal Studies programs here at the University of Arizona Law. Professor Swisher teaches legal ethics and procedure. He serves as ethics counsel and expert witness to lawyers, law firms, and judges, and represents indigent defendants in the Ninth Circuit. You might have heard Professor Swisher on NPR now and again, as I have. Professor Swisher's scholarship is regularly published and cited in the areas of legal and judicial ethics and disqualification, and he previously founded and edited the first blogs on judicial ethics and lawyer disqualification. He is a member of the ABA Standing Committee on Ethics and Professional Responsibility and has served on the editorial board of the ABA BNA Lawyer's Manual on Professional Conduct. In 2011, he received the ABA's Rosner and Rosner Young Lawyer Professionalism Award, and in 2016, the AJC's Learned Hand Emerging Leadership Award. Before entering the academy, he clerked for Judge Canby in the Ninth Circuit and practiced law at Osborne, Maladon, and Phoenix. Please join me in congratulating Professors O'Grady and Eldred for the publication of their new book, and thanking them all for joining us today for this very special book talk. All right, take it away.
Thank you so much. First and foremost, I wanted to give a hearty thank you to Teresa Miguel Stearns, Nikki Carpenter, and the entire Law Library enterprise for hosting this book talk series. And I think we'll all learn, if we don't already know, we'll learn quickly how impactful this particular book is that we're talking about today. But all of the talks that I've attended, the one last week, I think it was last week with Professor Bambauer, and the one coming up with Professor Simon, these have been wonderful intellectual gatherings, and couldn't thank you more for hosting them. And welcome to the audience for joining. You're in for a treat as we discuss Beyond the Rules, Behavioral Legal Ethics and Professional Responsibility. And those introductions were very kind. The two authors that we have with us, if you're in the field of professional responsibility, they would need no introduction. They're giants in the field, and looking forward to exploring this work with them. Just by way of brief background, this work found itself in a very traditional landscape, traditional legal ethics. It sort of assumes a rule or declares a rule, and that a rational ethical actor will invariably follow it, irrespective of the circumstances that they find themselves in and can't predict in advance. And you know what? If they don't follow that rule, they're just a bad apple and we should wash them out of the system. And then sometimes the rules give lawyers discretion. So for example, do you disclose that a client is about to commit a crime if you can't talk them out of it? We have discretion whether to do that or not. Just many areas like that. And we assume that the lawyer will follow in that situation their predetermined core values and any ethical theories that they might have thought of, perhaps starting in law school, and that they'll reach the right result for them and their clients. But behavioral legal ethics empirically calls these assumptions into question, and more positively, it supplements and provides nuance to our ways of understanding lawyers' behavior and ethical decision-making. So it builds on this very thin account of professional behavior that we had before behavioral legal ethics came along. And one note of personal privilege is I got to co-teach with Cathy O'Grady, one of the co-authors today. And Professor O'Grady worked in, by the way, I'm happy to see that there were two O'Gradys on this Zoom, if I recall. I think I saw Megan a minute ago. Professor O'Grady worked in some of the teachings in behavioral legal ethics. And what we saw from we saw it in the classroom, but what we saw from anonymous student surveys, that the students, importantly, really valued the subject. They really thought it supplemented the thin or traditional account that I just briefly highlighted for you. So I cannot be more excited to unpack this important work with you and our esteemed co-authors. Before we get started procedurally, I wanted to ask, Professor Eldred has a demo for us, and I wanted to know if there is any volunteer. Professor Eldred, does the volunteer need to be on Zoom or in the room to do a short, gentle demo? You won't know in advance what the problem is, but it will not be painful, I presume, and you certainly could withdraw your consent later if you choose to do so. But do we have a volunteer to do a brief demo with Professor Eldred in a few minutes?
Anybody? Yeah, I see a hand.
Sure.
Wonderful. Thank you. Thank you. But it's not quite up yet. We were just lining you up.
Great.
I know.
Who is our volunteer, Professor O'Grady?
Tell me your name, please.
Sen, S-E-N.
S-E-N, Sen.
Okay, excellent. Thank you so much for volunteering. I think it will actually be not only insightful, but enjoyable. And then I will, as Dean Miguel Stearns mentioned, I will be keeping the queue. So we should have time for a Q&A at the end. However, if you want to make a reservation with me, just send me a note in chat, and you will get the first or second or third question. Otherwise, we'll just open it up toward the end. So with those bit of introduction and procedural notes, Professor O'Grady, could you tell us what in the world is behavioral legal ethics, please?
I would be happy to. And let me start first by saying thank you to you, Keith, for serving as the facilitator for this conversation. Tigran and I both really appreciate your involvement, and also for your enthusiastic support of this project as we have gone through it. So thank you. And thank you to Teresa as well for organizing this. And thank you to all of you who are here in the audience and those on Zoom. This is exciting for us, obviously, to talk about this book. To have it published is a very exciting thing for us. And so we're very happy to share it with you and to talk about it today. So just to add a little bit to what's already been said about behavioral legal ethics, it is a relatively new and evolving discipline of study under the umbrella of professional responsibility, which looks, as we've said, beyond the rules of the model rules or the rules of professional conduct to ask, how do lawyers actually make ethical decisions when they're in the moment, when they're in the context of having to make a decision? So we look and focus on empirical research that gets at decision making and looks at various psychological factors, like cognitive heuristics that are, that frequently occur below our consciousness or under the radar screen as to how we're, evaluating information, assimilating data, and making a decision. We look at heuristics, mental shortcuts that happen very quickly when we're engaged in fast thinking, as opposed to slow, deliberative thinking. And we also look at the situational challenges and pressures that exist on lawyers when they make a decision. So those are very important aspects to putting the decision in context and taking it beyond the rules. And what what we found is that, as has been mentioned, in many professional responsibility classrooms across the country, every law school has to teach professional responsibility. It's required by the ABA. In those classrooms, students are studying the model rules and other related authorities, and they are, weighing the competing policies. And in many respects, often trying to decide, what's the idealistic decision here that a lawyer should make under this sort of ethical dilemma. And sitting in the classroom and kind of predicting, how would you decide this if you were the lawyer in this ethical dilemma? And this is all incredibly valuable and useful, but it just is incomplete because it doesn't factor in these dynamics, these psychological factors, biases, heuristics, and situational pressures that actually impact lawyers when they are making these decisions. So we take it beyond the rules to go into that direction. As I said, it's exciting for us because it is new, surprisingly so, I think. Behavioral ethics has been taught in business schools for years. It is not uncommon to us, our understanding of these concepts. But in law, it's very new. It's very new for us lawyers to think about this. So we're excited to be involved in the field. And that's a basic description of what it is.
Thank you so much. And Professor Eldred, touching a bit on what Professor O'Grady teased a bit, was who's your intended audience and why did you write this book?
Well, thanks to everybody. I want to echo what Kathy just said about thanking you, Keith, and thanking the rest of the school at University of Arizona. It's really wonderful to have the opportunity to speak about a subject that we have thought about for a while and care a lot about. And I have learned one lesson. Maybe I'll take a little bit of the last question that we might get to at the end of our discussion first, and say the most important lesson that I've learned, if you're going to write a book, is write it with Cathy O'Grady.
That's nice. Thank you.
A wonderful person to write a book with. In terms of the question that was just asked, I think that Cathy just kind of hit on a lot of what we were thinking about here, which is that we do think that the professional responsibility classroom really perhaps is in need of a supplemental component. We're not seeking to replace in any way the discussions of the core aspects of the rules of professional responsibility or the moral and ethical questions that get raised in the classroom. Those are all extremely important, but we wanted to bring in a new dimension, this idea that there is a lot of empirical research as to the question as to how people actually make ethical decisions. And we think it's important for us to both have an understanding of that, for students to have an understanding of that, and also to think a little bit about how we can tackle some of these difficult problems when we get out in practice, how maybe some awareness of the cognitive biases and the heuristics that Cathy just mentioned can influence our decisions so that perhaps we can make better decisions when we get out into practice. We also obviously want to reach practitioners if we can, and they're the ones right now who are making these decisions that impact their clients' lives, that impact other people's lives. We've been involved in a couple of different projects to try to create continuing education programs on this subject, including the creation of some materials for, I think, the largest provider of continuing education in the country, the Practicing Law Institute, which has gone out to hundreds of lawyers. We're happy about that. And we're just hoping that this book will add to that and that will be more opportunities for discussion of what we think is an important topic.
Thank you. So let's drill down a bit into the substance and frameworks here. And if you could, staying with you, Professor Eldred, could you tell us a bit about the biased reasoning that's highlighted in the book and how it impacts lawyers' ethical decisions? And Sen also offered to help with the demonstration if needed. So thank you.
Wonderful. Thank you, Sen. I'll be with you in 30 seconds. Just to preface this, because I don't want to give too much of an introduction before we do the demonstration, I just want to note that when we're talking about bias reasoning, we're not talking about bias in kind of the more traditional sense when we're thinking about, whether or not a particular group has been biased in one way or another. We're talking about this idea of psychological bias, this notion of a deviation from systemic rationality, which was mentioned in the introduction. So those biases are deviations from kind of pure rational decision making. That's really what we're talking about here. All right, Sen, are you ready? I don't know if you can hear me. I hope you can, and we can talk to each other.
Okay. He can hear you.
Okay, wonderful. All right, so just one proviso, which is if for some reason, Sen, you have done this exercise before or know of it, just let us know as I start down the road, because it doesn't work if you've done it before, okay? And for those of you in the audience, this is for everybody, even though Sen has graciously offered and volunteered to participate. I hope that you'll be thinking about the answers as well, and then we can talk about them together. So this is something that I do in my classroom, and I think it's a good introduction to some of these discussions. So Sen, this is what I'm going to do. I'm going to give you a sequence of 3 numbers, okay? And your job, and I have a rule in my head that sequence is an example of. And your job is to figure out what's the rule that's inside my head. So you can tell me what you think the rule is, and I'll tell you whether or not you're right or wrong. And you can do one additional thing, which is you can propose your own sequence of 3 numbers. And you can do this multiple times if you want. And I'll tell you whether or not it fits the rule. Okay, so just quickly to summarize, I'm going to give you a sequence of 3 numbers. It fits a rule that I'm thinking about. Your job is to figure out what that rule is. And you can ask me a question by proposing your own sequence of 3 numbers, and I'll tell you whether or not it fits the rule. Does that make sense?
Yep.
Okay, fantastic. And is this new for you, I hope?
I understand. I've never done this.
That's I guess what the question I was asking. Great. All right, so here we go. You ready? And for everybody in the room, be thinking, I guess, what sequences you would propose. All right, here's the sequence. 2, 4, and 8. And your job is to try to figure out what the rule is that is an example of.
I think the rule is you take the previous number and double it.
Okay, that is not the rule. That is not the rule. Now, you can ask me, you can propose your own sequence if you want, and I'll tell you whether or not it fits the rule.
You take the current number,
Just give us, you can give 3 numbers that.
Yeah. Yeah, so you can give your own sequence of 3 numbers if you want.
5, 10, and 20.
5, 10, and 20. Yes, that fits the rule. So what do you think the rule is?
You can give more numbers if you want to.
Yeah. And then you can also call on your colleagues if you'd like.
4, 8, and 16.
4, yes, 4, 8, and 16 fits the rule.
Really confirming my bias.
Well, let me ask you this. Do you have any idea what the rule is? Do you want to take another stab at what you think the rule is?
I can't come up with an alternative.
Okay.
So no,
Anybody else in the room want to propose a rule that our sequences fit?
Or some numbers? Yes.
Or some numbers?
1, 2, and 3.
1, 2, and 3. Yes, that fits the rule.
Do you have a guess as to the rule then?
Yeah, I think they're just increasing.
All right. Congratulations. You came up with the rule. Any 3 numbers in ascending order. All right, if I were there, I would kind of ask for a raise of hands of how many people had that rule in their head when we got to this point, but I won't put you on the spot. But what does this demonstrate? So this is a classic example of what's called confirmation bias, or at least I hope it seeks to demonstrate confirmation bias. And it's an example that comes from one of the more famous researchers in the field, someone by the name of Peter Wasson. And essentially what confirmation bias is this, it's a form of cognitive bias And it's a tendency that we all have. All human beings engage in confirmatory reasoning, and it is that we seek out information and we interpret information in a way that's consistent with our pre-existing beliefs. Right? The idea here is that we don't just kind of consume information neutrally, but rather we have a pre-existing view. And as information comes in, we filter it as to whether or not it confirms those pre-existing views. So I want to hypothesize that what was going on, Sen, for you and maybe for many other people in the room, is that when I gave you those three numbers, you immediately started to, you kind of came up with an idea in your head as to what you thought the rule was. And then you started to look for examples in your head that were consistent with the rule that you had hypothesized. And that's the way that most people would I think, try to answer this question in the way that most people do. Now, the initial hypothesis was wrong, but it turns out that someone in the room ultimately came up with the right hypothesis. The scientists in the room, for those of you who are scientists, know that scientific reasoning looks at this problem very differently. Scientists don't say to themselves, when I'm trying to figure out whether or not my hypothesis is true, let me figure out if I can come up with examples that show me that are examples that the hypothesis is true. They try to disconfirm, right? Disprove the existence of a hypothesis as opposed to prove the existence of a hypothesis. And that's why the scientific method is much more rigorous than kind of the way that the human brain tends to operate. But for a variety of cognitive reasons, the human brain tends to filter information in this way, which is that we seek out information in a way that's consistent with our pre-existing beliefs. And it turns out that this idea of confirmation bias is actually a really essential part of what we talk about when we're talking about behavioral legal ethics, because lawyers are human beings, right? And lawyers tend to filter information in the same way. So instead of kind of consuming information in a neutral way, it turns out that all of us, when we're practicing law, at least the research suggests, are also susceptible to this idea that we're going to gather information to confirm our pre-existing beliefs. Now, there's an additional wrinkle to this, which is not just that we're seeking out information that's consistent with our original beliefs, but that we seek out information that's consistent with our desires, right? Our wants and our wishes. So this is called motivated reasoning. I don't know if anybody in the room has ever heard that phrase. But the idea here is that not only are we gathering information and interpreting information so as to confirm what we know, but to seek out information in a way that's going to get us the answer that we want. Now, confirmation bias and motivated reasoning and most of the other cognitive biases and heuristics that we'll talk about over the next half an hour or 45 minutes happen at a level below conscious awareness. So Sen, I suspect that you didn't realize while you were doing this that you were engaging in a confirmatory reasoning process, like most of us wouldn't. And if you think about it, we couldn't live without confirmatory reasoning, right? When you kind of go through your day, if you had to question every piece of information that came into your brain, you would never get anything done. You'd constantly be thinking, well, is it true? Is it not true? We have to filter it. And that's one of the reasons why we do engage in confirmatory reasoning. So the general idea here is that lawyers are people too. We engage in both confirmatory biases. We have confirmatory biases. We engage in motivated reasoning. We are susceptible to a whole range of other cognitive biases, and that these biases and heuristics influence the types of decisions that we make when we make decisions on behalf of our clients, when we make decisions on behalf of third parties, when we're thinking about duties of candor to the court. Our role as partisans can significantly influence how we make decisions, the information that we gather, and how we interpret that information, and it will affect the types of decisions that we make. So I think for the rest of our talk, we'll talk in maybe some more specific ways about how those biases can influence us, but those are some of the preliminary ideas.
If it's okay, Keith, I'd like to just interject something quickly here on confirmation bias for the students that we have in the room. As Teresa mentioned, I like to think about new attorneys and how some of these heuristics, biases, and situational forces impact new attorneys. And with confirmation bias in particular, it's easy to make that connection because new attorneys working in work teams with more senior lawyers typically do a lot of the legal research that's involved in the work. And frequently, there is a suggestion from the senior lawyers and from your work team as to what you want the result to be, right? So you tend to, human nature under using confirmation bias tends to look for examples to confirm that. And then as you continue to research, you look for more and more confirmatory evidence that just reinforces that that's correct, that must be correct, I must be on the right track. but failing because of the confirmation bias to take account for the disconfirming evidence. And so it's very risky to engage in that kind of dynamic as a new lawyer working on a team doing the legal research, because you could miss something that's really important, but it doesn't confirm, in fact, disconfirms the premise that's put forward to you. That's just an example of one example among many of how confirmation bias might work in the practice of law for new attorneys.
And if you're thinking about motivated reasoning, not so much in the context of the practice of law, we'll talk about a number of examples where it applies, but I just like to talk about, the political dynamic of our world right now. Think about how one's political predispositions often tends to influence the type of information that we gather, right? In fact, people often look for their own information silos. Maybe if you're on one side of the political spectrum seeking information in one source and another side of the political spectrum seeking information from another source, that tends to be the way that a lot of people gather their information. So, motivated reasoning is happening all the time as well.
It's such good points. I mean, especially as you hinted on the environment where you're already sort of you're hired typically by one side. And so you already have this sort of partisan bias and the whole, implicating the whole ecosystem here that you're working in. So such excellent points. And you also mentioned that talking a little bit more about some of the specific or practical aspects. Professor O'Grady, the book has several chapters devoted to discussing the impact of behavioral legal ethics principles in specific practice areas. Can you tell us why this is important for lawyers who, for example, are in-house counsel with companies?
Yes, we spend a chapter or part of a chapter on in-house counsel for companies. And in a professional responsibility class, you generally spend at least a class on this dynamic, this type of lawyer. It's very fascinating because think about it, the lawyer that's in-house with the company is actually an employee for their client. And so that dynamic right there puts them in a very unique position. Their bonuses, their pay, their success in their jobs, their promotion, their work, a lot of corporate in-house counsel work up the corporate ladder to very high positions within the company. This is all dependent on how they are perceived, how they do for that company, for the executives that hired them and who they work for. But their client is actually the organization itself and not the executives of the organization. So they have a responsibility under the model rules to be always cognizant of perhaps the shareholders or the board or the company itself as opposed to the CEO. And that really puts them in a very unusual position that can sometimes raise a lot of conflicts. There has been some interesting work out there on this particular lawyer in this dynamic. One is, for example, some researchers did work interviewing just in-house counsel. So they were focused on this target audience. And they did two things. They asked them a number of questions so they could get a sense of their identity. And this is the formation of identity theory. Do they see themselves more as a lawyer who happens to work in an organization, or do they see themselves as an employee of the organization? And they asked a number of different factors to put them on a scale for identity, which is interesting in and of itself. About half saw themselves as both, but almost 20% said they see themselves as employees of the corporation. But then they went further and asked a number of vignettes, ethical questions, to get to see whether their identity actually impacted how they would decide the question, and whether they would take an organizational approach to deciding the ethical dilemma or whether they would take a professional, independent approach to deciding it. And they found that that identity definitely impacted how they would decide the ethical question. So I like that research because it targets right in on the lawyers that work in this area. And I'll just give you a quick example. So in-house counsel frequently works with outside counsel, looks at the bills that they generate, reviews the invoices. One of the vignettes posited that the outside counsel was a good friend of the CEO's, but as their work continued, the in-house counsel thought, these bills are getting really high. I think we're being overcharged here. So how would they proceed then? Would they do an independent evaluation, looking at other firms of similar quality? What would they charge? What are we getting for our money? And take that to the CEO? Or would they go directly to the CEO and say, you know, I'm concerned we're being overcharged. Would you like me to look into this? I could do a little bit of an analysis. And if the CEO said, no, don't worry about it, then they would let it drop. And a significant number chose that alternative view, which is the organizational perspective that works within the company. And of course, there's lots of ethical requirements on in-house counsel to make sure that the company is protected from possible liability. They need to sometimes report up when behavior, if they perceive that behavior is going to be engaged in that's fraudulent or wrongdoing, and that people cannot be dissuaded from doing otherwise, they have an obligation to report. And sometimes behavioral concepts can help explain maybe why they don't do that. So we look at that in the book, and we look at other things as well, like motivated blindness, which is kind of a corollary to motivated reasoning, and why it is that that when we have this perspective ingrained, for example, in the in-house counsel, they may be literally blind to information that they don't wish to see about what's happening inside the corporation. That's just so that's a little bit of attention in the book to that area.
Thank you. It's interesting because sometimes folks will say, well, it's a rosier environment in a corporation or an organization, perhaps, where money is flowing in and you have additional people and resources to implement some of the strategies suggested in the book. But it seems like your strategies could be applied elsewhere as well. And I was wondering, Professor Eldred, how might this apply, these behavioral legal ethics insights apply to criminal law practitioners?
Well, I mean, I think that the general underlying kind of science that we cite in the book applies probably in all practice areas. We've highlighted a few in the book, as Kathy just mentioned. In the corporate context, we have a chapter on prosecutors, on defense lawyers, and on civil government lawyers. So I'll just spend a few minutes talking about the criminal adjudicators, the prosecutors, and the defense lawyers. And it's interesting because some of these same dynamics come into play, I think, in ways that both prosecutors and defense lawyers for indigent clients mostly do their work, and yet they have very different effects. On the prosecution side, prosecutors are supposed to administer justice. They're not just supposed to be partisans. The rules are pretty clear about that. And yet the question becomes, under what circumstances and why is it that a prosecutor might engage, of course, and I'm not talking about all prosecutors now, I'm talking about in certain instances, might engage in unethical behavior, might engage in the type of misconduct that we hear about frequently, too frequently, unfortunately, in the news about, the suppression of exculpatory evidence or other bad acts that may result in a wrongful conviction. And Kathy and I, when we were looking at this, thought that, the psychology that we've been talking about has something to say. It's probably not the only explanation, but it's part of the explanation. I don't know if anybody in the room has heard the concept tunnel vision before, as applies to prosecutors, but it's become very much part of the kind of the reformist discussion about how to address prosecutorial misconduct, both with prosecutors and in law enforcement. And the general idea of tunnel vision, which is another way of basically talking about confirmation bias and motivated reasoning, is this idea that once law enforcement and perhaps the prosecutor, as they get involved in the case early on, kind of fixates on an individual as the person who allegedly committed the crime, because maybe there was an initial identification of that person or some inculpatory evidence suggested that that person was the culprit, that the focus becomes completely on that person, i.e., all of the attention is inside the tunnel. And that the exculpatory evidence or the information that suggests that the person isn't the person who committed the crime, i.e., that information that's outside of the tunnel, gets discounted or often ignored. And again, this has to do, I think, with these ideas of confirmatory reasoning, that it's very strong impulse to seek out and confirm pre-existing hypotheses, as well as a series of motivations that can come into play. I mean, in criminal cases, especially in high-profile cases, it's very important for the prosecution and law enforcement to have a good working relationship. So if law enforcement believes that they have the right person, it's easy for the prosecutor to kind of get on board as opposed to exercising a degree of independent judgment. If you've got a serious crime that has got a lot of media attention, there might be a lot of scrutiny of the case and a desire to clear it relatively clearly. And if come up with an initial culprit, thinking that's the person who's committed the crime. So we spent a lot of time in the chapter talking about that. I don't know if anybody in the audience, I suspect some people have, saw the docuseries on Netflix called Making a Murderer, which is about this case about Stephen Avery, who is someone who is prosecuted for a pretty horrible, grisly murder in Wisconsin, and whether or not he committed the crime. We spent a lot of time in the chapter talking about the predicate crime. It turns out that he spent 18 years in jail for a crime that everyone agrees he didn't commit. DNA evidence demonstrated that he didn't commit the crime. And the question is, why was he falsely accused and ultimately falsely convicted? And I think that a lot of what we've been talking about helps to explain it. Tunnel vision is at the core, perhaps, of what happened in that case. So I'm happy to talk in more detail if anybody's interested. On the defense side, the same situational variables and biases can exist. You've got, especially in the indigent defense context, you've got lawyers in many parts of the country, not everywhere, who are working under tremendously difficult conditions. They've got excessive caseloads. Too often they're under-resourced. Very often public defenders in many places don't have the resources that they need to do the job. Contract lawyers who are working in small counties who might be getting paid on a flat basis in order to take on a certain number of cases don't have enough resources. And so you've kind of got this kind of what is called almost an assembly line process that happens in the criminal justice system too often, where defendants are, there's strong incentives on the defendant through defense lawyers to plead guilty. The argument goes, well, it may be that that's in the best interest of the client, but really, is that ethical lawyering? Is the lawyer doing all the work that the ethical obligations require of them? Are they properly investigating the case? Are they properly determining if there's an alibi? Are they scrutinizing the strength of the prosecution's evidence? Are they doing the legal work necessary to see if there's a proper motion to dismiss and the like? And very frequently, we find that work is not being done. And the question becomes why? Again, I don't think that there's a lot of intentional misconduct out there. In other words, I don't think there's a lot of defense lawyers who go into public defense thinking, I'm going to screw my clients. That's not what's motivating defense lawyers. But it's easy to get caught up in a system that kind of is very much about processing cases and getting numb to this process. And before one knows it, those are the circumstances that are ripe for confirmatory reasoning. Well, my client's been accused of a crime. There seems to be some evidence against them. It might be in the best interest of the client just to move this case quickly and get the case resolved. Motivated reasoning, I just don't have enough time to work on all my cases, so I'm going to have to kind of triage some of these cases. These cases I'm just going to kind of deal with quickly so that I can spend a lot of my time on a few of the cases, and a number of other kind of psychological factors. So it's interesting. Prosecutors may be influenced by these factors, and as a result are maybe becoming overly aggressive and producing wrongful convictions. Defense lawyers may be influenced by these factors and not acting aggressively enough in their cases, not acting zealously enough, and clients aren't getting the representation that they deserve. Opposite sides of the same coin.
Thank you. And Professor O'Grady, you'd mentioned earlier in the context of confirmation bias and how it presents risks to new attorneys. Would you like to elaborate any further? An important audience is new attorneys, and any other principles you'd like to relate as especially applicable to them?
Sure. Maybe I'll just mention two. One, to follow up on Tigran's point about the situation that you're practicing in, those external forces as they impact criminal lawyers. But with regard to new attorneys, I'm really interested in that because most new attorneys join some sort of work team. They work for a firm or they work for an agency. And they are frequently, if it's a hierarchical work team, they are at the bottom of that hierarchy. So there's a lot of situational dynamics that can occur just from that alone. There's one old study that shows if there's anything unethical that needs to be done by the work team, it's going to be handed to the lowest lawyer on the totem pole to do. That's pretty alarming if that were to play out. And that led me to think about wrongful obedience, Stanley Milgram's work at Yale in the 1960s, and how that might apply to our hierarchical work teams in law and in the practice of law. And I don't think you'll be surprised to learn that the model rules don't forgive a brand new associate who is just following orders from a senior partner if they are engaging something, unarguably unethical, say. And we do have cases. I have a case study in the book of a brand new lawyer who was disbarred in Kentucky for following orders from a senior partner with regard to misleading the clients. So wrongful obedience is really an interesting one. And then the other thing that I've really enjoyed looking into a little bit, I don't know if enjoy is the right word, but I spend a little time thinking about the whole notion of billable hours, the legal fee structures and billable hours, because we still live in a world where most firms bill clients by the hour, and most lawyers are rewarded for the number of hours that they bill. And that creates these bizarre incentives to, to work slowly, to overturn or overbill a case, and then to fraudulently pad hours, thinking that, well, I'm just going to, and we get into the rationalizations that go on when that happens. And I'm just going to borrow some hours from next month that I'll use for this month because I'm short now, and engage in those things. This is something that, I have seen young lawyers do, and unfortunately, and so the theory is that it is, of course, unethical. Make no doubt about it. The ABA has been clear. You can't pad your timesheets ethically. So the question then becomes, well, so what? If it's just a little thing that we're doing here, the rationalizations that can lead new lawyers to do something like that, and maybe they don't know the client well, so they're in a multi-layered team, so they have, this seems like a victimless sort of crime. Who cares if the company has a few more hours? The notion of the slippery slope then comes into play, and the research that dominates that area. You start with a small transgression, and it can just lead down the road until suddenly you've forgotten who you are as an attorney, and you wake up and think, what's going on here? What am I doing? It's not beyond the pale to consider the implications of that when you start small and then it builds. So we spend a little time thinking about the billable hour structure and those temptations to pad that result. I'm frankly surprised that we still have a system in law that we bill our clients by the hour and the minute and that kind of thing. It just seems that there are other models that would be better, but I think there's no perfect model. So we've ended up sticking with this, and that's what we have as a status quo in law.
Thank you so much. One of the things, to me, that's influential about this new field is it does seem to explain empirically what's going on. I know sometimes there are questions about replication or cross-situational factors, but it does seem to explain empirically, or as you say in the book, descriptively of what's happening. But one of my favorite chapters in the book is chapter 11, where you talk about solutions. So it's about what sort of prophylactic or other measures could firms, public defenders' offices, or individuals put in place to help lead individuals or individual lawyers to make better decisions. Professor Eldred, would you like to comment on what some of those solutions might look like?
Sure, thank you. At the end of the day, I think we have to be humble and recognize that these are powerful psychological and situational factors. So we're not suggesting that we have either all of the answer or many of the answers, but the research does suggest that there are some things that we can do. Because so many of these biases happen below the level of consciousness. In other words, we're not aware of our confirmatory reasoning. We're not aware that we're engaging in a motivated reasoning process most of the time. These situational variables like obedience that Kathy was talking about influence us in very subtle ways that we're not so aware of. It's hard to kind of in the moment address them. So one of the suggestions that we have is this idea of pre-planning, right? That if you know that you might be subjected to some of these variables, the best way to handle that is to, in advance, recognize it and try not to get yourself into those situations. So kind of getting back to Kathy's point about the slippery slope, there's all this research that suggests that small transgressions beget bigger and bigger transgressions, more serious violations. That's why it's so important to be really focused and attentive to not engaging in the small violations. The client calls up and says, the client that kind of tends to be a little annoying and calls once too many perhaps times that for your liking, calls up and the answer is to your legal assistant, just tell him I'm not here. when you are here, right? That's the smallest of white lies. But if we don't engage in the smallest of white lies, maybe we can kind of prevent the larger ones from happening down the pike. I'm not suggesting that that necessarily leads to the more serious ones all the time, but that's one of the ideas. The second idea that comes out of the research, and there's been some really interesting scholarship in this area. Let's talk, for example, about prosecutors. Again, this idea of tunnel vision and this notion that there's such a strong, zealous desire to get a conviction, to not think about perhaps all of the evidence that's exculpatory. Well, perhaps what we need to do is be a little bit more humble about our own knowledge base and think of, well, maybe there's a way to think about this in the opposite. You know, what would the other side say under these circumstances? And maybe they have some good points that I need to consider. I mean, prosecutors' offices, there's a movement to try to come up with a devil's advocate, someone whose job inside the office is to actually try to point opposite to the position that the lead prosecutor is taking, just so that there's some balance to that idea between what the prosecutor is doing, you know, in a particular case and whether or not that's just. There are a number of other suggestions that we make with regard to what individuals can do, but I have to say that I think we both agree that most of the work here has to be done at the systemic level. Because again, at the individual level, it just turns out that we're not aware when we're biased most frequently. So better to set up structures that make it less likely that we'll be subject to those biases than depend on our own individual capabilities in the moment.
And I'll jump in here just a little bit because I did some research on the systemic level solutions that we might be able to think about. And, you know, there are so many common sense solutions for law firms and agencies, but the thing is they need to apply them. They need to do it. And I think sometimes that might take some associates getting together and saying, we want this. But one, for example, one common sense and I think very effective solution for firms, no matter what size they are, is to appoint one partner to be an ethics counsel or an ethics person at the firm. Sometimes it's more than one, but this is a safe space now for attorneys to go and ask confidential questions about ethics, the things that are bothering them that might be occurring on their team or in their workplace, or to talk with about mistake. Another area that I'm interested in. They feel that they've made a mistake or they've almost made a mistake and they need to come and talk to somebody about it before it escalates and becomes even worse. So a lot of large firms do this. This is pretty common among large firms to have in-house ethics counsel, but medium-sized firms, I did a survey in Arizona many years ago now, I guess, through the state bar that looked at medium-sized and small firms as well, and found that they don't do this. Perhaps they think they're too small, they don't need to do something like that, but by not doing it, they are depriving new lawyers of a resource, a place to go, and they're also they're failing to model how important ethical decisions are within the structure of that firm, no matter how small it is. So that's just a really common sense approach. And then there are others. I talked to a firm in Connecticut, great firm, who did a lot of ethical reminders. The ethics counsel there, senior partner, would send out these very funny, humorous, very short emails that just would remind lawyers periodically, once a week or once every couple of weeks, about some ethical decisions, how to write a good engagement letter, or just remember that you have us to rely on, that you can talk to. So those are just two approaches. There are many more that we talk about, and it's just a question of getting them in place. And then I think they actually do some good.
Excellent tips. Thank you. And I know we had a few other questions on critical reactions and whatnot, but in the interest of time, I want to turn to the audience. Let me just first say, and I'll probably sound like a West academic sales representative when I say this, but you really should consider reading or buying the book. It's very concise. It's very readable. It's one of those books where you can get through it very quickly. And for those professors in the room who teach on or near these subjects, it could be I think a very fulfilling supplement to a course. So thank you so much for writing the book. We have an audience question in the online queue already. Professor Eldred and I cannot see the audience. So Professor O'Grady, you are our eyes.
We have at least one question here in the audience. So however you want to begin.
Okay, well, I'll start with Professor Spiess's question. It's whether this behavioral legal ethics makes reference to formal ethical theories proposed by various philosophers. And Professor Spies, of course, feel free to supplement what I just read, but that is the core of the question.
Tigran, do you want to try that?
Well, I don't think that I have seen anyone who's written about it from a philosophical perspective. In terms of the kind of the primary debates that have taken place inside of the legal ethics community about, what is the proper model or frame through which to understand what legal ethics is, either kind of a maximalist approach that the job of the lawyer is to do everything short of violating the law that will advance the client's interest, versus a more minimalist approach that recognizes perhaps that there are separate independent ethical obligations that lawyers have that they should advance irrespective of whether or not it advances a client's interest. We talk a little bit about that in the book and recognize the fact that it's interesting that, notwithstanding the fact that there are these big kind of debates within the legal ethics community, it seems that everybody takes as a fundamental assumption the notion that lawyers will be able to make their decisions based on this kind of rational cost-benefit calculus as to what, they can just look at available information and decide whether or not they should or shouldn't act in a particular way. So we think that the behavioral side of this, the question of whether or not these biases and heuristics influence decision making, apply irrespective of whether or not one takes a maximalist approach or a more minimalist approach. But I'm not actually aware of any philosophical intersections with the behavioral science. I don't know if you are, Kathy.
No, that's just exactly what I would have thought too. So we have a question
From
here.
what you described,
Oh,
it sounds like consequentialism. You just look at the cost benefit. So it's a utilitarian calculus, which a lot of people think that's not even ethics.
all right, we have a question in the audience.
Thank you so much, both of you. It's been really interesting to think about this. And I'm wondering, I'd like you to talk a little bit about what law schools could do better. So many students from this school go into smaller firms or solo practice. There isn't even that potential of systemic reinforcement when they get out. And I served for 6 years on the former Attorney Discipline Commission in Arizona, kind of an appellate panel over, all ethical violations that were sifting up through the state bar and to the Arizona Supreme Court. And what we found was most of those violations weren't misrepresentation or, conflicts of interest. It was client neglect. And it seemed to me that we don't do a great job in law school really trying to inculcate this notion of responsibility, fiduciary responsibility for a client, to prepare our students. And I think ethics, it needs to be taught in a separate course, but it also needs to be something that's taught throughout the curriculum because it comes up so much. Anyway, if you might talk a little bit about law schools, how they figure in.
Yeah, I'll just jump in on that a little bit. I agree completely that this pervasive notion of teaching ethics is so important. And it's likely that we do it a little bit and we don't even know that we're doing it in different classes. Maybe we haven't really dug deep enough to figure out what's going on in all the different classes. In particular, in clinics, where students are working with clients to be able to sort of integrate all the ethics of decision making into that model, and maybe even have students keep journals about ethical dilemmas they've encountered or what they've seen other lawyers encounter. All so important to supplement just this class that we have that we call professional responsibility. There's only so much we can do in the class. And I agree, I've heard and seen studies that suggest that the #1 complaint clients have about lawyers is that they're not getting their phone messages returned, or they're not getting the attention that they think they deserve to their case. And there's really something there for us to work with our students. We do need to do a better job of impressing the importance of that responsibility on them throughout the law school, and even training beyond law school. That's the other thing I found. Many law firms don't do their own training in this area. And I don't know why. I wish they would, but maybe we could help. Yeah.
I hope you don't mind me plugging one additional item, which is that for anybody in the room or who might be watching this who's interested in having their students learn more about the material, the book we hope will be useful. In addition, as I mentioned, the Practicing Law Institute did an hour-long interactive program called Motivated Reasoning and Legal Ethics. And if you're teaching in the legal ethics world, you can get that for free. I'm happy to help make that happen, or I can provide Kathy with that information and we can get it disseminated. But I think it's an interesting interactive video exercise that we used professional actors who created simulations that are then, I think, pretty three-dimensional in interactive exercises. So anyway, it's just another opportunity to think about this material in a different way.
You know, Ed, there's a lot of important insights in the book that we just didn't have time to cover. I mean, one is, as you mentioned, articulating an individual's core values and that sort of refresh, or writing down lines that you will not cross, and has been shown to hold promise to when someone does face a tough ethical question. And it bears on too the professional identity charge that law schools have recently received from the regulators, or creditors, so that working those types of exercises in the classroom. So I would commend this book and its insights to the audience. And Professor Spiess's question, I often think of how does this whole field impact how we think about determinism and free will and choice and all those things. But I know it transcends our discussion, and I know we're at 101 right now. But thanks so much for the thoughtful discussion. I'll turn it over to Dean Miguel Stearns if she has anything else to add, but thanks so much for joining us.
Well, thank you, Professor Swisher, and maybe there's volume 2 coming along the way. And so join me in thanking Professors O'Grady and Swisher and Eldred. It's a wonderful book. Thank you so much.
Thanks, everybody. Bye, Tigran.
Thank you.
Thank you, everybody.
Bye, Roy. Thank you.
Bye.